Hey guys, so today's session is going to be about just the general visa cancellation powers and how they work. Although I'll be talking about some character sections, but I'm not going to go in detail with the character cancellations and the powers there. Okay, so you know who I am. This is me, Kris Ahn, Principal and Solicitor Director of Kris Ahn Lawyers, and my journey in immigration law started in 2008 when I was interning at a migration firm. And then as soon as I became a lawyer, I couldn't avoid working in immigration law, so I started working at a small general practice, but that quickly focused and specialized in immigration law. So that was back in 2011, and here we are. So I'm very, very close to meeting my 15th year in being a lawyer, solicitor, and also officially working in immigration law. So I started with as a registered migration agent, because back then it was a dual regulated era, and my MARN started with 1/1, so 11, marking my starting year. So the objectives of the session is I'll just be doing like an introductory information about the visa cancellations, some key sections of the law, how they are applied, and also the consequential effect. So just because a person's visa is cancelled, that is not the only thing that you should be focusing on. You need to understand how that cancellation affects this person's future migration elements, as well as if they had a member of the family as a secondary visa holders, how does it affect them is another consideration that we need to make. And then how to effectively draft and prepare responses and submissions for the NOICC, or notification of intention to consider cancellation, and then a review application to the ART and responses to the NOICC when we do receive it. So the visa cancellation. So if I may, there are three different types of visa cancellations. As I've highlighted here, there's a discretionary cancellation, mandatory cancellation, and automatic cancellations. Most cancellation powers are discretionary cancellations. These discretionary cancellations are the ones where you are provided with a natural justice, such as the NOICC, or notification of intention to consider cancel. So if the department gives you an opportunity to provide a mitigating response, or satisfied that the cancellation grounds that they have identified do not exist, that opportunity is what we call a discretionary cancellation. So the department will consider whether they will cancel or go ahead with the cancellation after receiving this information. Mandatory cancellations are cancellations that will just happen if the grounds for the cancellations are met. For example, the one that I could think of right now is I know that it's not meant to be for character, but section 501(3)(a, I think, top of my head. So that's the one where if the person has been sentenced for more than 12 months imprisonment, and if that person serves the time, the minister must cancel this person's visa, and there is no natural justice. So the cancellation will happen, and then there will be an offer of revocation if they are able to satisfy or convince the ministers or the delegates that they should revoke the cancellation or set aside the cancellation and reinstate the person's visa because of mitigating factors and such. Automatic cancellations are the one that I can think of is section 140 cancellations. There's a consequential cancellations. So for example, if you're the primary visa holder and if you have your family members, and as a primary visa holder, if you have found to breach visa conditions or were not entitled to this specific visa, and the department cancelled the primary visa holder's visa, then the secondary visa holder's visa will automatically be cancelled, even though they did not breach or had any compliance issues, and that's done automatically. There's no discretion, and it's not really a mandatory cancellation, but it's what we call an automatic cancellation. So there are three different types, and there are many different cancellation powers. So section 109, 116, 128, 140, 501, 134, I think, and these are the things that I'll be discussing today. And at the end of these slides, I have created an appendix, and it summarizes the cancellation powers, identify whether if it's mandatory or discretionary, whether if it can be reviewed, and generally, what grounds that the department uses. So the typical ones that we commonly see are the section 109, 116, and 128. Section 109 is the incorrect information of bogus documents. So any visas can be cancelled under Section 109. What I mean by any, like there's no, both the temporary, provisional and permanent visas can be cancelled. Now, yesterday, Tony has shared a department's internal policy outline that the incorrect information does not necessarily have to be material to the grant of the visa. So even if that specific information that was provided identified to be misleading or false, and even though it had no real weight or material, it was not, whether if it was material to the grant of the visa does not matter. So immigration can use that to try to cancel the visa under Section 109. But the most common one that I do see, sometimes very, very difficult to identify when we work, is immigration using the entry card to Australia. So, when you are returning from overseas trip to Australia, on the plane, they usually hand out this like a yellowish, orange little cardboard slip that you need to fill in. That's actually like an entry form, like a piece of application form that you need to fill in, not only just for any temporary visa holders, but even for us as Australian citizens or permanent residents, that they need to fill in. And if you provide false and misleading information or incorrect information, immigration can use that and will use that to cancel your visa under Section 109. The legal grounds for the Section 116 is it's generally used for the temporary visa holders and not for permanent visas if they are in Australia. But permanent visa holders, before they come to Australia, before they have their first entry, Section 116 does have the jurisdiction, but Section 116 does not have the jurisdiction for the permanent visa holders who are already in Australia. And 116 is general for changing circumstances. And this is why, if you think about it, the partner visa holders, after they get their permanent residency and when they separate or divorce their Australian sponsor, the department cannot use the Section 116 to cancel permanent partner visa holder because Section 116 does not have the legal jurisdictional power to, because it's not a temporary visa anymore. And same thing goes for the ENS visa holders. 186 visa is a permanent visa, and after they get the visa and immediately, let's say about a week later, if they quit the employment with the sponsor, then immigration cannot use Section 116 to cancel the visa holder's visa. The only way that they can is by using the Section 109. So, for example, arguing if immigration has, in the first instance, if immigration has any evidence that the relationship had actually ceased before the grant of the permanent partner visa, then they could use that to argue that incorrect information or misleading information was provided at the time of decision because the client or the visa applicant did not notify the department of the changes in circumstances. And the second one, second instance for the ENS, I've never seen this being successfully argued, but theoretically, on the ENS visa application, the visa applicants must make a declaration that they are committed in working with the sponsoring business for at least 2 years after the visa is granted. But if somehow there are contradicting evidence, then immigration may be able to use that to argue and cancel the ENS visa holder's visa. But again, both 109 and 116 are discretionary cancellations. So even if they do have such evidence, they can't just cancel a person's visa. They do have to provide natural justice, issue a NOICC, and then give the opportunity for the visa holder to provide their comments or mitigating factors why their visa shouldn't be cancelled. And Section 128, cancellation of visa while the visa holder is outside of Australia. So Section 128 can only apply when the temporary visa holder is outside of Australia and is cancelled on the grounds of Section 116. And this is the scary cancellation. I have seen cases where the department had just cancelled a person's visa almost instantaneously as they left Australia. What that tells me is the department was aware of the breach or the non-compliance. They just waited for the visa holder to leave Australia so they could cancel this visa under Section 128. And that's the scary thing, because Section 128 does not need or does not have a natural justice. So they don't legally, they don't issue any NOICC and they just cancel. And this cancellation notice is gone to the last known address or the email of the visa holder. So it's quite common for the visa holder not to know and realize that the visa has been cancelled. And of course, the notification in itself may be challenged, whether the case officers have followed the correct procedures in notifying such cancellations. notices because the cancellation notice itself must be valid. If it is not valid, then we might be able to challenge the validity of the cancellation notification itself, but that's beside the point. But assuming that everything is there, then it can be cancelled almost immediately as the visa holder is outside of Australia. And once the visa is cancelled, I think under section 131, the visa holder is entitled to a request for a revocation, but that revocation request must be submitted within 28 days, and there is absolutely no extension of time. So strategically and practically, what you do have to do is at least submit a revocation request and then keep providing the documents and supporting evidences after you submit the revocation. The revocation request must be in within that 28 days, but legally there's nothing stopping you from providing any further supporting evidence after that date. But yeah, the revocation must be in the 28 days. Jurisdiction. So not all cancellations are reviewable under the migration law and the merits review. Of course, it can be argued that all administrative decisions made by the department and the minister can be reviewed at the courts, depending on the circumstances, subject to the elements of the law. But for this session, we are just talking about the ART merits review cases and cancellation decisions by the delegates under section 109, 116, 134F, 137Q. 137Q is no longer becoming that relevant anymore because it's a RSMS cancellation. But anyways, 142 and non-revocation decisions on the 137L are reviewable by tribunal. But here, I think generally speaking, we are more experienced dealing with 109 and 116. I don't have any exposure to 134F and 142 and 137L. But yeah, just knowing that such reviewable is important. And of course, if you want to check, you can always check section 338 of the Migration Act to see the jurisdiction of the tribunal. Important thing is such decision will be reviewable even where the primary decision is invalid. What it means by that is because the delegate failed to comply with the mandatory procedural requirements set out in the Act. So this is what I meant earlier about the notification procedure. Cancellations commonly have issues with the delegates not providing or not following the correct procedure in notifying the cancellations. So this is where we say that that decision is invalid if the delegate or the case officer did not really follow that procedure, but still we can seek review. And where the visa applicant should not have been granted, where the visa would have already expired at the time of the tribunal's decision. Yeah, so for example, the department may cancel a visa that is set to expire tomorrow. So I'm holding a student visa, but it's expiring tomorrow. But immigration, after all the NOICC and everything, they just cancel me today. And I literally had one more day left on my student visa. I can still seek a review of this student visa cancellation, even though my student visa technically, by the time that it is being reviewed, technically it wouldn't be valid. But the reason why we would do that is if you are successful in setting aside the cancellation. After this session, if you do go back and check the Schedule 1 of visas such as 485 visa, there are some provisions where the person is able to make a valid 485 visa after the tribunal has set aside the cancellation decisions, or I think sometimes review. So there are some provisions there. So this is why it might still be beneficial to seek a review, even though the timeline may not seem to be in your client's favor. And where the person who made the purported decision lacked the requisite delegation just means that not every case officer can cancel a person's visa, especially when dealing with the 501 cancellations, because some cancellations can only come from a minister. And when we say the minister, does not necessarily mean the actual minister of immigration and citizenship, but it can still be somewhat delegated. But that delegation, we need to check whether if that person had the legal power to do so. So that's what it means, and we can still seek merits review on those cases. So again, the appendix that I have included at the end of the slides, which I'll try to go through and summarize what type of cancellations have reviewable powers. So a prescribed period to apply for review. So it's become so much easier now. Before the ART, some cancellations had 7 days or 14 days and all this, but now pretty much everything is within 28 days. So the introduction of the Administrative Review Tribunal did and has made this review time frame so much easier to understand. The only thing that you do have to remember is if the person is in the immigration detention, then we must lodge it within 7 days. Otherwise, it's just 28 days now. I had to do like triple check on this timeline as I was preparing this, because I'm so used to, for the last over a decade, trying to work out, how many days and, but now it's pretty much everything is 28 days. So consequential effects of cancellation and cancellation powers. And these consequential effects, or the consequences of the cancellations, are very, very important for you to understand for two reasons. Of course, number one is understanding and being able to adequately plan for the worst case scenario when your client's visa is cancelled. But also understanding that we could argue and put those positive, or spin that around and use it to try to convince the case officer not to cancel because of these consequential effects, because the consequences of cancellations are also part of the department or the delegate's considerations in determining whether to cancel a person's visa or not. So understanding the consequences are very, very important for those two elements. So if a person's visa is cancelled on the 109 and 116, a visa held by another person on the basis being a member of the family unit of the first person is also cancelled by operation of the law. And this is what I was telling you under section 140, the consequential cancellations. So again, if you're the primary visa holder and if you have secondary visa holders who have obtained their visas because of your satisfaction of the primary visa criteria, but the department had cancelled your visa for whatever the reason, then the secondary visa holder's visa will be cancelled under section 140 subsection 1. Pretty much. So that's just automatic cancellation. So your non-compliance, or the primary visa holder's non-compliance, inadvertently affects the secondary visa holders. And we could try to argue that that's not really fair. And depending on the family's, circumstances, if there is a child, then we could argue the best interest of the child. If the secondary visa holder was doing something really, really good for the Australian community, then we could try to emphasize that, even though it's not the secondary visa holder that's being considered for cancellation, but because of this consequential cancellations, we could try to squeeze that into the argument as mitigating factors for not cancelling your primary visa holder's visa. And others who hold a visa because of a cancelled visa may also be subject to a mandatory or discretionary cancellations. This one is, say, for example, if you've been sponsored on a partner visa and your partner or the sponsor is a Australian permanent resident, but if immigration cancel your sponsor's permanent residency for whatever reason, your visa could also be cancelled if you are on a 820, not the 801 but 820. So that could be that. And even if you are on a 801, that could also be cancelled as well. So that's another consequential. So even though we are talking about the actual sponsor, sponsors cancellation could have a flow-over effect on the visa holders whom they sponsored. If a person holds a bridging visa in association with a visa application and their substantive visa is cancelled, the bridging visa ceases immediately upon the so this is a common thing. So let's say your client was holding a student visa and they apply for a partner visa, valid. But for example, student visa holder, because after applying for the partner visa, they didn't know that they had to continue going to school, and they didn't. And the department, when finding out that, their COE has been cancelled and the record of their compliance with the education requirement is not met, the department may choose to cancel this person's visa, student visa. What happened is, if the partner visa has not yet been decided, they would have been granted a bridging visa, but by cancelling this person's student visa, that bridging visa that they held will also be cancelled. But thankfully, the partner visa will still be in process. So in those cases, what we do need to do is help them obtain a bridging visa E associated with the partner visa that is still ongoing. But that's another consequences of a visa cancellation. And cancellation of a visa on character grounds under 501 results in deemed refusal of any other undecided and non-protection visa applications. So what this pretty much means is, if your visa was cancelled on the character grounds, you will be banned to apply for any other visa applications. I think I could have written a better term. It's not a deemed refusal. I should have said maybe an invalid application. So it's act as almost like a section 48 bar. Pretty much every visa except for a protection visa and also bridging visa R is the only visa that is allowed, including bridging visa E. That's can't be applied for and can't be granted. That's what it's trying to mean. And here you go, statutory bar. So anyways, statutory bar is section 48. is another consequence, of course. If a person has a substantive visa cancelled in Australia, then they are generally not able to make a valid application while they are in Australia, except for some prescribed visas, and you'll find that in the regulations 2.12 of the regulations. And typically, those are the partner visas, medical treatment visas, protection visas, and some regional visas. But one thing that I do wanted to highlight, and I think I put in a slide here, is not all cancellations are captured under the Section 48 bar, not all of them, and I'll highlight that later. Another statutory bar is the Section 501E. This is the one that I just mentioned before. If you have a visa cancelled under Section 501 because of the character grounds, you can only apply for. So it's not an eligibility issue, it's more of a validity issue of the application. So you can only make a valid application for a protection visa or a bridging visa R while they're in Australia. So let's say you did something wrong and immigration cancels you on 501, and they're, oh crap, what can I do? I can apply for a protection visa. So if you have advised and assisted in client applying for a protection visa, thinking that could save your client and keep them lawfully in Australia, that's a very, very poor decision unless the applicant or your client is a genuine refugee. Because applying for a valid protection visa, they're not even entitled to any other bridging visas associated, because that bridging visa, you can't even make a valid application for it. And this is where I try to look for any other ways. And if you look at the wordings of the Section 501E, they talk about they are unable to make a valid application for it. So I try to look for any other ways to help our clients to obtain a valid visa or a bridging visa without an application, because some bridging visas can be granted by operation of the law. But to do that, they need to make a valid application for some other visas. And ultimately, I just couldn't find any, loopholes or anything like it about it. So once a person's visa has been refused or even cancelled, so I know that we're only talking about cancellation here, but this 501E also applies to somebody's visa being refused on 501, then they are pretty much doomed. And only way that they could stay in Australia is probably by going to the immigration detention centre, unless they somehow hide and get away from the authorities. And then other consequences are, of course, the PIC, public interest criteria, 413. So 413 is the only applies in some cancellations, some and most cancellations, but not all. And it is a re-entry bar, or I know that it's generally considered as a re-entry bar, but it also applies to prevent any grant of generally temporary visas in Australia for 3 years, unless you are able to satisfy the minister that there are compelling or compassionate circumstances that affect the interest of Australia or Australian citizens. But again, because we are talking about temporary visas, it's not very easy to find any compelling or compassionate grounds that affects the interests of Australian citizens or Australia as a country. So I did highlight that not all cancellations trigger 4013. One example that I can think of is 482 cancellations. So a 482 cancellation could occur if your client obtained a visa, and then they were terminated from employment with their sponsor. And thankfully, now they have 6 months to find a new sponsor and be subject to an approved nomination. But let's say they just couldn't for the 6 months. So then technically, that gives power for immigration to cancel this person's 482 visa. And that cancellation does not trigger the PIC 4013. Another one is voluntary cancellations. You have the power to request the department to cancel your temporary visa voluntarily, and that voluntary cancellation does not trigger PIC 4013. Knowing this, sometimes it's beneficial for your client to request for the voluntary cancellations, even though they may have been non-compliant for an extended period of time, so you're preemptively just triggering the voluntary cancellations instead of the non-compliance cancellation. So to avoid the PIC 4013, depending on the circumstances. So those are the other strategies that you can rely on. But PIC 4013, it can be quite, I wouldn't say complex, but it's got a lot of elements that you need to understand. So student visa is one of the visas that's being captured, but not all condition breach leads to a trigger of 4013. So this is why knowing and understanding is it. And when a client comes to you with a cancellation, you have to really look at the grounds and the reasons why the person cancelled to figure out whether a 3-year bar because of 4013 applies to this person. So yeah, you need to really look into the Schedule 4. And then the PIC 4014, the genuine re-entry ban, and which is only triggered when the person departs Australia, and it is triggered when they depart Australia as a unlawful non-citizen or as a holder of a bridging visa C, D or E, but not always. What I mean by that is, even though a person may have had a visa cancelled and somehow, if they leave Australia unlawful, but if they do leave within 28 days from holding their last substantive visa, then the PIC 4014 does not apply because they left within that 28-day grace period. Likewise, if they had obtained the bridging visa C within 28 days of their visa cancelling, then again, they're not subject to the 3-year ban or PIC 4014 ban. They might be subject to PIC 4013, but PIC 4014 is not applied. So those are the other things that you need to be aware of. So yeah, PIC 4013 and especially PIC 4014, a lot of migration agents and lawyers, they just automatically assume that a person is subject to it just because they left Australia or they are leaving Australia as a holder of these identified bridging visas or unlawfully. But there are some exemptions, and that's I think identified in PIC 4014 sub-item subparagraph 5, I think. So you need to really study that. And then the statutory bars or the special returns criteria, yeah, it really only applies if the person was deported or removed from Australia. I have actually not seen them, or maybe I did, but I just told them that, look, because of the SRC requirements, you're not eligible to come back. But yeah, but the cancellations, cancellation but cancellation just means that the person becomes unlawful and the department, they might immediately detain them into the immigration detention center. And if they were removed from Australia from the detention center, then automatically SRC applies. So this is something that you need to review. And of course, unlawful status, what I just explained. So it is obvious consequence of cancellation. So when your visa is cancelled, even though you may have held another bridging visa or bridging visas from your other substantial visa application, all of your bridging visas will also be cancelled, and immediately because of the cancellation, you become unlawful. Of course, you may be entitled to apply for another visa, not all of them, but Section 48, like reviewing the Section 48 elements and other bridging visas, you might be eligible to legalize yourself one way or another, but the fact of the matter is you'll be unlawful, and that affects your ability to apply and legalize yourself in the future. So considerations is, okay, so your client's visa was cancelled, and now remembering all the PIC restrictions and everything, you need to be able to work out immediately what visa the client can apply in Australia if they wanted to, and how can you help them apply for it. So for example, if a person's visa was cancelled, let's say subclass 190, we know that subclass 190 is exempted from the Section 48 bar. I think since 23rd of November 2021, I think that's when that they introduced it during COVID. But to make a valid application for subclass 190, not only that they need to be invited, but let's just assume even if they are invited, but they must be holding a bridging visa C, a substantive visa, or bridging visa A, B, or C. If your client holds a bridging visa E, too bad, you can't. So to help your client, then you need to be able to figure out, okay, so ultimately we want to help our client applying for this subclass 190 or subclass 494 or whatever, that a visa that they can apply in Australia, and that would lead to a permanent residency ultimately. But to do that, you need to help your client getting a bridging visa C at least, because you know that getting a bridging visa A or B is impossible. So then how can we get our clients to hold our bridging visa C? And this is where we try to help them apply for other visas like medical treatment visa or protection visa, even though they're not eligible. And as lawyers, I know it's very questionable, and I know that the department doesn't like it, but look, as lawyers, we owe duty to the courts, not to the department. If we were migration agents, we cannot do that. But as lawyers, my argument is, we're lawyers. We owe duty to the courts, not to you guys. And as lawyers, we are using the law in the best interest of our clients. And if they are able to make the application and benefit from the byproduct, which is the bridging visas that they get, why the hell not? You can refuse our visa and then application, and we will appeal because our clients have the entitlement. That's my argument. Yeah, so in doing so, we get bridging visa Cs, and during that time, we will help our clients to, hopefully get that invitation if they're going for 190, or, get the sponsorship for the 494 in the regional area. And it's one of the ways that we have been helping a lot of our clients. And a good example of that is there is a client, this client from UK, she did the dodgy second working holiday visa. So she paid this person and then got the second working holiday visa without ever doing the farm work or the specified work. But immigration found out and they cancelled her visa. So I helped her apply for the protection visa, knowing very well that she's not eligible to do so, and I helped her get work rights. But see, this also you have to remember, not only that PIC 4013 applied, so within the next 3 years she wasn't able to apply for any temporary visas or anything like that. Thankfully we avoided getting the triggering the PIC 4014, but because the working holiday visa was tainted with false and misleading information and bogus document, I was aware that PIC 4020 would be an issue. For how many years? Just 1 year, not 3, because she held a tainted visa, and so for the next 12 months she shouldn't be making any applications, but she was never refused a visa because of PIC 4020, and the 3 year only applies if you're refused a visa by PIC 4020. So for the next 1 year, I just told her to, stay quietly and then just, be on the visa. But at the same time, let's prepare for the next visa. And turns out she had like an education, I think it was a primary or secondary education qualifications, and she had a number of work experiences and everything. So we were able to apply for the expression of interest as a teacher, secondary teacher, and she got the invitation and we applied for the 190 visa after that one year period. PIC 4013 does not apply to the 190 visa, so we were able to apply that within the 3 year period. So knowing this, I was able to assist that client in that way. So from a person that immigration just canceled the visa for providing false and misleading information, she became a permanent resident. Yes, Tony.
So for this client, even if she get the PR later, because the previous non-compliance of providing incorrect information, her PR may be cancelled under Section 109. Is that correct?
But so Section 109, she did not provide any false and misleading information to the 190 application, but I believe there is a Section 107A, I think, that has like a reach into whatever the visa that she was holding before. But there was a gap. So she was holding a working holiday visa, and then that was cancelled. She wasn't holding a substantive visa, but she was holding a bridging visa C. So I don't think that cancellation power 109 could affect her, and it hasn't. Does that make sense?
Is it say if a visa is cancelled by effect of incorrect information once, department cannot use this fact to cancel any following visas? Is that the thing?
I have seen the department cancelling or using 109 more than once. I think what the jurisdiction is that they can't use the same grounds to cancel a person's visa more than twice. It's the same grounds, but I'll give you an example. So this is the example actually relates to my one of my other strategies that I'm going to share with you during this session. One of the strategies that I like to do is if the department tries to cancel a person's permanent residency, immediately before the cancellation, I help the clients to apply for RRV, residence return visa. And residence return visa does not have PIC 4020. So legally and theoretically, it can be granted, and it does get granted. So then once the RRV is granted by the operation of Section 82, the visa that the department wanted to cancel no longer exists. So that cancellation power, they can't utilize cancelling. I'll put it into perspective. So let's say a partner visa. Okay, so your client holds a partner visa, but that partner visa was granted on the basis of false, misleading information about the relationship, and department figured it out. So they wanted to cancel your client's partner visa, permanent partner visa. And before they could cancel, you quickly apply for the RIV, and let's say the RIV for the client was granted. And because the client no longer holds the partner visa, the department cannot cancel your client's partner visa. So then what the department can do is they could use that, not section 109, well, part of the 109, but I think, again, section 107. Sorry, I can't seem to log into my Legend at the moment for some reason, but yeah, it's one of that section. And they could use that to try to cancel your 115, and they could. But the question is, can they use the same grounds to cancel others? The same grounds, meaning in this specific scenario, the department would have cancelled the RRV subclass 155, isn't it? Yeah, section 155, on the basis that they were not entitled to hold a permanent visa because the originating permanent visa, which is a partner visa, was obtained on a false and misleading information or incorrect answers. But if the RIV was cancelled, but before the RIV cancellation, I could actually apply for the client's another RIV. And let's say the department purposely did not process the second RIV, but leading to the first RIV being cancelled. But ultimately, the department has to process the second RIV by way of Section 47, because I made the valid application, and Section 47 of the Migration Act goes, the minister must assess and decide to either refuse or grant, but they can't refuse the RRVs because at the time of application, the applicant was holding a permanent visa, and so they will ultimately grant it. But can they then cancel the second RRV on the same reason, the repeat reason? I think that's what you're trying to ask, and I actually have seen it. And maybe you and I, after this session, let's study that case, because the department does and has cancelled this person's visa on those same grounds multiple times. But I think it could, what you're trying to say is maybe when immigration cancels it and when we successfully appeal it at the tribunal, without doing that whole RIV thing, partner visa is cancelled, we appeal it, and we successfully get that cancellation set aside, the department cannot use that grounds to cancel the visa again. I think that's how it's meant to work, and that's the purpose of the legislation. Does that make sense?
Yeah.
Sure.
Thank you.
Cool. And then, so that was the Schedule 1, understanding the subsequent visa or the future applications, what you can do with the client, knowing. And then there's Schedule 3 criteria. Schedule 3 is a dying breed. It's being phased out. So any new visa subclasses do not have Schedule 3 criteria. So I call it the archaic visas, like partner visas. Partner visa hasn't changed in decades. 482 is relatively new because it was introduced back in 2018. Before the 482, it was 457, and 457 had the Schedule 3. So all of these Schedule 3 issues and all that, it's becoming less and less important, but still is very important for visas, typically such as partner visas, because they are still tested. But yeah, Schedule 3 criteria is also another thing that we need to be aware of, where a person must have held a substantive visa at the time of application. I think it's 3001 or 3002 that also has a temporal element, that they must have held a substantive visa within less than 28 days from the date that they apply for the substantive visa. So that's the Schedule 3. So how to draft submissions to the NOICC. The very, very first consideration that you must make is whatever the department is claiming, is it true? So does the department really have the jurisdiction or the grounds for the cancellation exist? And that's one thing. And first, you might think that, oh, that's stupid. Like, they wouldn't really act on it, without doing their own research. And that's true. Department, because most of the cancellations are discretionary, they don't really like to start the cancellation procedure until they are very, very sure. But recently I had one case cancelled when they actually didn't have the grounds for cancellation. That was the one where immigration cancelled my client's ETA visa because my client had two registered date of birth. His original date of birth, I say original, on the record was incorrectly recorded. So later in life, he amended it. And during that process, he had history of entering Australia on the original birthday, and then later on he amended the birthday and obtained a new passport and entered Australia on a different, but he never provided any false and misleading information because the ETA application does not have any field on the form to declare any alternate or differing birth dates. Differing names, yes, there is a field, but any birthday, no. But immigration cancelled my client's visa on the basis that he never declared of his different birthday. And we argued, articulating that, look, you guys don't even have this field or whatever option to declare this. And the client had never had any intention to mislead. And ultimately, the department agreed that there was no grounds for cancellation, and they set aside the client's visa. But the aftermath is now the department is preventing my client to benefit using the ETA system. So he's unable to apply for the ETA visa using the app how he used to. And they are making him apply for the 600 visa and all that, and they are refusing his visa. It's very, very unfair of what's happening, but that's something that's, that could happen. But really identifying whether the grounds exist is one important element. The Miyake and Kaji, this case is pretty much about, for some cancellation powers, there are regulated considerations, legal considerations that the case officer must make, and they must consider each and every element or the considerations that's legislated. It's very, very logical. Like, you might think that, of course, but, within the decision records, they must go through each of the items or the regulated items considerations. If they don't, then they made a jurisdictional error. That's what the case law is about. So the section 109 has those regulated things, but here we go. Section 116, there are no prescribed regulated circumstances, but it's under the policy. So even though it's under the policy, the department must follow their own policy. But I guess when it goes to the merits review and all that, I guess that's a different field. So the tribunal members, they could refer to the policy, but they don't have to follow the consideration elements of the policy. But general rule is there a compelling circumstances that weighs favorably to the applicant or the visa holder? If the answer is yes, then they should be making a favorable decision to the visa holders. Unlike the power to grant, so this all there. Sorry, my time is sort of up, but I actually did this seminar to a bunch of other lawyers for legal wise seminars a while back then, and everybody used to ask me, can I get a template or all that? And my simple response is the best template that you can ever find is through OSLI or through JADE. Look at the recent and relevant decisions made by the tribunal with the cancellations, because that really shows their structure in decision making and considerations. And my submissions generally follow how the tribunal makes their own decisions. And in my honest opinion, that is the best template that you could find. So I think that's the most important part. So these are the relevant prescribed considerations that I mentioned before. So they must identify and follow through. Another thing that I wanted to emphasize is the Australia's obligations. This is what I wanted to tell you. Even though Australia's international obligations are part of the considerations, such as we had a client who was from Myanmar and whose visa was considered being cancelled because he provided an incorrect answer on his student visa that he has held before. And Myanmar, as you guys know, is currently, in a horrible state of war, internal conflict and all that. So we try to argue that Australia owes a international obligation, non-refoulement obligation to this client. But after digging in and checking all the case laws and precedents and everything, what we have found, even though that's part of the consideration, the decision makers were not wrong in making a decision saying, yep, despite this, I still cancel because technically you still can apply for the protection visa afterwards. So unless the visa that they are considering to cancel is a protection visa, if it is not, then the decision maker can still cancel your visa, even though the person is positively identified to have Australia owes non-refoulement obligations to this client. So that's one thing that I have found recently, actually. So I wanted to share that with you guys. So really quickly, strategies. I didn't write it here, but the very first thing that a lot of people don't do is really check when the correct due date is. And to do so, you need to first identify whether the official NOICC was sent by a registered post or by email. Now, what I mean by that is the department generally sends the original and the official NOICC by registered post, and at the same time emails a copy to the visa holder. And a lot of the time, many people, including some lawyers, mistake that the time starts when they receive this email, the 5 working business day, like the working day calculation. But you need to check whether if it was officially stated to be transmitted by a registered post or by email. So it's rather clear on the NOICC itself. And then do your calculations very carefully, taking in consideration of any public holidays. And you might need to check the Acts Interpretation Act if you wanted to, all that. But that should be the very first thing as soon as you receive your NOICC. And then the second thing is, before the visa is cancelled, you need to check whether if the client can apply for any other visas. So this is where I talked about the RIV for the permanent visa holder. I don't care whether if the client has foolproof evidence that the visa must not be cancelled. I think identifying other visas that the client can apply for and trying to convince the client to apply for that other visa is and should be one of the key things that you should do. Because my experience dealing with the delegates is, if they wanted to, they started this NOICC cancellation progress because they want to cancel your client's visa. And it's not very easy to convince a delegate not to cancel or not to do what they are originally intending to do. So it's very hard. So it is always important, in my opinion, to have this backup plan. So that's one thing. So visas to apply for before an existing visa is cancelled. Why before? Because once the visa is cancelled, Section 48 bar kicks in. That's why. And the residence return visa for the PR holders is my favorite choice. So it's all there. And Section 48 bar. Oh yeah. So this is what another. So bonus for Section 140 cancellations. So the automatic cancellation for the family members, Section 48 does not capture them. So you don't see any Section 40 cancellations as part of the cancellation subject to Section 48 bar. So that's one other thing that I'm yet to benefit of it. Oh, thankfully, I don't have that many clients whose visa got ultimately cancelled. But look, thankfully, but having this knowledge hopefully will benefit your other and future clients. Okay, and this is the appendix that I mentioned before. So Section 109 MRD. So MRD really means migration and refugee reviewable. Natural justice applies. Yeah, so this is the appendix for the cancellations. Okay, so I think that's it. Thanks guys for joining me today.